The criminal justice system in Nigeria is very slow. Statistics have shown that 70% of inmates in Nigerian correctional centers are awaiting trial. Some spend more years waiting for their trial than the number of years they would have served if they have been convicted of the offense. To address some of the challenges, the administration of the Criminal Justice Act was enacted in 2015. But analysts say not much has changed. Here, justices of the Supreme Court and Court of Appeal are gathered for a two-day colloquium by the Nigerian Institute of Advanced Legal Studies in collaboration with MacArthur Foundation to discuss how to make the Act more responsive to the need of the society. Chief Justice of Nigeria, Justice Tanko Muhammad, said the administration of criminal justice is important for a better society.
The Administration of Criminal Justice Act 2015 is a revolutionary legislation in our criminal justice system. Its primary purpose is to ensure that the system of administration of criminal justice in Nigeria promotes efficient management of criminal justice institutions, speedy dispensation of justice, protection of the society from crime, and protection of the rights and interests of the suspect, the defendant, and the victim.
President of the Court of Appeal, Justice Monica Dongban Mensam, promised to ensure the full implementation of the Act, even as she calls for a re-examination of the provisions of the Act to identify areas of potential conflict.
This event offers us the chance to examine the Act and, more specifically, highlight areas of potential conflicts and interpretation. There is therefore need for the provisions to be re-examined with a view to comprehending its objective in our criminal procedural law.
Is for us to take stock in the last 6 years, on the part of our appellate justices, the extent to which they have applied the provisions of ACJA and how far it has aided in anti-corruption cases that they have handled, and then the extent to which our lower court judges, that is federal and state high courts, are also coping with the understanding of the technical and innovative provisions in ACJA and how far they have fared in its implementation.
The law is what the Supreme Court says it is, because the Constitution gives to the Supreme Court the power to interpret the law, and whatever interpretation the Supreme Court gives binds the entire federation. That's why the Nigerian Institute of Advanced Legal Studies has put together this colloquium to interact with the appellate justices, justices of the Court of Appeal and justices of the Supreme Court, so that they will be fully attuned to the fundamental objectives and purposes of the Administration of Criminal Justice Act.
The two-day event is expected to throw up discussions on the administration of Criminal Justice Act 2015 and how the judiciary can address some of the concerns. Punarman Fentola, Arise News.